Ladies and gentlemen, welcome back to Power Vacuum. I'm your host, Belmont. And you gotta love the continuing saga of Pokemon v Power World, Nintendo v Pocket Pair. We have this article from Automaton Media, which I found very interesting based on the headline. So let's dive in. Nintendo may not be able to recoup legal. Let me start over. Nintendo may not be able to recoup legal expenses of Power World lawsuit even if it wins, Japanese attorney suggests. Japanese patent attorney Kiyoshi Kurihara shares new insights on the lawsuit between Nintendo and Palworld developer PocketPair. It's been almost 9 months since Nintendo and the Pokemon Company logged a patent infringement lawsuit against Palworld developer PocketPair. The latest official update on the case came last month from PocketPair's side when the developer confirmed that prolonged litigation was still ongoing and announced that it would reluctantly be changing some of its game mechanics as a direct result of the lawsuit. Going off court documents shared by Games Fray, Japanese patent attorney Kiyoshi Kurihara recently shared some insights on how the case is looking at the moment. According to Kurihara, Pocket Pair has been following a standard legal strategy to defend itself so far. These include denying infringement, claiming invalidity of Nintendo's patent rights based on prior art found in existing games, arguing lack of novelty and lack of inventive step. He notes that while some past lawsuits like the Nintendo v. Colapole, I guess, infringement case saw Nintendo in an overwhelmingly advantageous position, the Power World case feels much less one-sided by comparison. This time it appears to be a typical patent infringement case where both parties are engaging in a rapid back and forth, pushing for invalidity and infringement respectively. Interestingly, Kurihara also suggests that the scale of the lawsuit could potentially make it somewhat fruitless for Nintendo. To assert its claims against Palworld, Nintendo is employing lawyers from TMI Associations, one of Japan's top five law firms, which has multiple bases across Japan, Singapore, Silicon Valley, London, etc., and specializes in intellectual property cases. On the other hand, Pocket Pair is also being represented by major international law firm Nishimura and Asahi, with both parties enlisting high profile legal teams. Kurihara comments, although it's a crude point to bring up, I can't help but think that Nintendo may not be able to recoup the legal costs even if they win. The exception would be if Nintendo were to increase their claim amount from the current 10 million yen, around 67,000 US dollars. Meanwhile, see, that's the thing that kills me. I got to pause for a second. $67,000 does not seem like a lot of money for a game company that was pretty much the number one game the month it came out. I guess I'd have to look at their total sales and units, but I feel like they made well above 60,000, but or 67,000, but it's just I don't know. Seems like a lowball estimate. Meanwhile, it had to compromise on game mechanics like throwing PAL spheres and gliding on PALs. Pocket Pair is still actively updating and putting out new content for Power World. The game's next major update, Palworld Tides of Terraria, is scheduled to come out in September 2025. There you have it. Nintendo might be spending more on their litigation and legal battle than they're asking for in restitution. And it could be a fruitless endeavor. Although I think the point of the lawsuit is more to set future precedents, which would give them, you know, them and many other companies authority to pull this same bullshit. I really want Nintendo to lose because I don't think companies should have the ability to retroactively alter patents or update patents and affect companies that have games put out that might infringe upon these suddenly updated and altered patents. It's just ridiculous to think that they can do this. It's kind of obnoxious. But we saw, we're going to do a double dip article here because I also saw this one from Automaton Media. And we're just going to cover everything we can that's out and available about this insane lawsuit. But Palworld changing game mechanics because of a Nintendo lawsuit isn't an admission of infringement, Japanese patent attorney stresses. Japanese IP attorney addresses some of the backlash Pocket Pair has been receiving in Japan over the Nintendo lawsuit. If you read the headline and thought, well, duh, does that even need to be said? You're probably on the same page as many of the English speaking community. However, reactions to the patent infringement lawsuit between Nintendo and Pocket Pair have been quite different in Japan and in the West. Than in the West? I think they mean than in the West, which became especially apparent after the Palworld developer announced it would be swapping out game mechanics relevant to the case. While opinions in Japan are like anywhere, varied and shouldn't be generalized, Japanese patent attorney Kiyoshi Kurihara felt it necessary to address some of the backlash Pocket Pair received following its May update. In the statement, the dev says that they are continuing to dispute both claims and allege infringement as well as the validity of Nintendo's patents. At the same time, they announced that gliding on pals and summoning them by throwing pal spheres would be removed from Palworld to prevent further disruption to its development. According to Kurihara, this resulted in a good number of responses along the lines of, why would they change their game if they really believe Nintendo's patents are invalid? And looking at Pocket Pair's post and their Japanese X account, there's a noticeable number of responses that interpret the decision as an admission of infringement. Addressing such reactions, Kurihara explains that Pocket Pair's motive is standard procedure in patent infringement lawsuits, precautionary design change in a typical measure taken alongside denying infringement and counterclaiming patent invalidity. This is a lawsuit, Kurihara stresses. You need to make every arrangement you can. Additionally, he explained that the plaintiffs do not typically cite design changes as an admission that the defendant acknowledges patent validity. So yeah, this is part of the ongoing battle, and it's good to see the lawyer speaking up. I guess in Japan, a lot of people are considering this an admission of guilt, where in the United States or the West, where I am, it's not. We just go, yeah, we call it CYA, cover your ass, and that's what they're doing. They're covering their ass because you don't want to give them any ammunition that they don't need when it comes to a lawsuit, because this is Nintendo's playing dirty games, and when they play dirty games, they're willing to commit dirty acts. But yeah, that's pretty much it. Um, Power World currently not in the wrong, battle ongoing, and Nintendo might be spending more money and lose. Well, they're not actually losing money, believe it or not, which blew my mind. Pokemon, I think, had like record-breaking sales. I might cover that in another video, but it, they're losing fans somewhat, but they're still Nintendo, one of the largest, most dominant gaming companies in the world. It's just I don't know. It's so dirty to try this nonsense with the patents and doing retroactive updates. And I really, really, really hope Power World wins this one for all indie developers and all game makers everywhere. But that's all I have for this story. This is your host, Belmont, signing out.